Welcome, everyone. Thank you for joining. We are here for the November edition of the Nonprofit CLE series. Today, we're going to be talking about nonprofits and artificial intelligence, or AI, legal considerations amid the ongoing developments. I am AJ Zatola. I'm a partner here at Venable in the IP and the nonprofit practices. And I'll allow Channing to introduce herself.
And I was on mute, so I'll do that again. My name is Channing Gatewood, and I'm an associate within Venable's Intellectual Property Transactions Group. Thank you.
Next slide, Channing. So we have a packed agenda today. First, we're going to kind of broadly address AI and how it might relate to the nonprofit world. Next, we'll go over some basic terms. This is not going to be a deep dive today, as I suspect many of our guests are sort of new to this topic. So we've kind of broken this down into two considerations. We have what we call the inputs, being the components of the AI that occur before or at the moment of submitting information. Here, you're going to see a lot more of the privacy considerations, but also other things to consider with respect to submission of content or data, or the allowance of the submission of content to data, and applicable regulations. Then we'll move on to the outputs. This is going to talk about the considerations to make when evaluating or using the material received from the AI platform. Many of you might be surprised to hear that it is not always accurate, but chief among the legal concerns are copyright ownership considerations, other types of IP rights, and then frankly, at this stage in time, a number of IP loopholes, as a number of elements in the IP world relating to AI have not been fully resolved. Finally, we'll talk about best practices, thoughtful utilization of AI. We're not here to tell you not to use it, and some related legal considerations. Next slide, please. So what is AI? There are a lot of definitions out there that have been given, but for purposes of our talk today, AI, or artificial intelligence, refers generally to a type of software that is trained to perform a particular task. And many of these tasks may be highly relevant to the nonprofit community, including drawing conclusions, identifying patterns, making judgments. It can also be used for image recognition, image generation, voice assistance, speech to text, translation, chatbots, etc. Frankly, notwithstanding the fact that AI kind of burst onto the scene in 2023, this isn't a new piece of technology. Some elements of it have been around for a number of years, in particular speech to text or translation. However, AI is getting better. It is more complex, and it's generating more interest because it can be used these days to generate increasingly more complicated outputs from more complex or natural language prompts, the input. So there is more and more use of AI, and you might find AI replacing things previously done by humans. Next slide, please. So why do we care about AI? Why are nonprofit organizations using it? Well, to a large extent, it kind of boils down to these four items. It is making it easy to quickly create content or analyze data. So you have elements of speed and efficiency at play here. It's getting easier to gather information, to develop answers, to generate content, to generate responses. The other aspect of this is that it's in the news pretty much every day these days. So this is very much an on-trend topic, and use of AI may demonstrate, strangely, that your organization is keeping up with technology and using modern tools. And so nonprofit organizations are using AI. AI can be used primarily to generate campaign data, perhaps, or analyze data related to donors or other types of solicitations, and certainly can be of use when generating written communications. But that doesn't necessarily mean that that you should be freely utilized or freely ingested. And so we're going to talk a little bit about some of the considerations to consider. Next slide, please. You're on mute, Channing. Why don't you just unmute yourself for the remainder of the presentation?
Will do. Didn't want my clicks to be heard. Thank you. So as AJ said, now we're going to talk about some of the legal implications of AI. So why is it important to look at artificial intelligence through a legal lens? And the answer is what we have on the screen, is that almost everything comes from something, meaning that organizations utilizing AI platforms should be aware that nearly all material that is generated by the AI platform is based on pre-existing material. At worst, this could mean that an organization uses an AI platform to distribute an AI-generated work, such as a AI-generated advertisement. An unrelated third party could then argue that the organization is profiting from an ad that is based on that third party's own work, being that the AI platform was trained by the third party's scraped content, among other scraped content. This sort of lawsuit is not a guaranteed outcome, of course, but the potential exists. So organizations using AI platforms should be aware of that potential when reviewing and approving content for publication. Other legal issues that may arise from using an AI platform are potential violation of privacy laws or breaches of confidentiality or other contractual obligations, depending on what information in particular is submitted to the AI platform. And lastly, as we will discuss in the best practices section toward the end of the presentation, an organization looking to partner with an AI platform provider to license use of an AI platform for its particular organization, that organization should work with legal counsel to review and negotiate the terms of that licensing agreement to clarify provisions such as data ownership and security, remedies for breaches or violations of applicable laws, and other legal terms to ensure that the arrangement is not unintentionally detrimental to the organization that's looking to license the AI product. We've highlighted on this screen several terms describing the AI technology itself, the platforms that host the technology, and related terms. This is by no means an exhaustive list of all terms concerning AI, but these are terms that we will occasionally use throughout the presentation. First is generative AI, which is a particular type of artificial intelligence as opposed to simply AI. As the term suggests, generative AI refers to AI that is able to create or generate new content based on the input provided to it, which can involve generating text, images, video, and audio. And unlike traditional AI, which can simply summarize, organize, etc., the information that it receives, generative AI takes that information and creates something new. Next is AI model, which is a program that relies on data training and analysis to identify patterns and make other determinations. Certain types of AI models include deep neural networks, linear regression, and large language models. This is more of a computer science term, which is a bit beyond the scope of our presentation, but we've listed it here to note that AI platforms, which is the next term, the platforms use and are based on particular computer models, which inform how the particular platform operates. So for example, whether a platform responds to text prompts with text, or whether the platform develops images. For example, the functionality of the platform depends on the type of AI model within the AI platform. So knowing the type of AI model that's informing a platform may help an organization make a more informed decision when selecting an AI platform to meet its needs. Next is AI platform. This refers to the particular program or application that hosts the AI model and generates the corresponding output to the user. For the purposes of this presentation, the AI platform term will also include broadly popular AI brands that have become pretty notorious this year, such as OpenAI, ChatGPT, which is under OpenAI, Google AI, or similar programs, as well as the AI models within those platforms. Next is inputs. which is the content a user submits to the AI platform. An example of this would be the text prompt that a user submits to an AI platform that responds to text questions and prompts. Output is next, which is the content the user receives from the AI platform. So the text the user receives back in response to its prompt. Scraping is the act of pulling information from one website or platform and placing it into another website or platform in a new format. Many AI models or platforms are based on scraped data. And lastly, in this list, training data is the data often scraped from a variety of online sources, which is then used to inform the AI platform as it analyzes input and generates output.
So we simplistically have broken this down into inputs and outputs to both illustrate some of the legal considerations in the background and to help everyone visualize how to look at AI issues. The input, as it were, is two levels. It is first based in part on what the user submits to trigger the platform to generate output of one kind or another, the prompt, as it were. But it also relates to the training data, which the AI platform or tool already has, and which it's constantly updating to analyze that input or submitted prompt and inform the output. And so you have here, among the considerations, a lot of data and privacy concerns and things to consider with respect to what kind of content to put into the model or what the model can use. And then finally, what are the applicable laws and regulations that may govern this process? Next slide, please. So the input is primarily coming from two sources, which we'll talk about. First is scraping. The second is the data itself that the user is submitting. So this would be the nonprofit user. Next slide, please. So scraping, what is it? It's been around for a while. Many of you in the nonprofit field have been concerned about it as it relates to event or vendor attendee lists, but it is, generally speaking, the act of pulling data from one place into another. And this is by and large how many AI tools have developed their training data. And it largely is built on third-party data, which means that there can be issues associated with where the data came from, whether or not the data was lawfully gathered, whether scraping in of itself is permissible. The other thing to think about is whether or not the nature of the data that's being scraped is something that can be used by the tool in of itself. And this is why there are privacy concerns. Personal information in particular may not necessarily be usable in all contexts. And so when you go to a source and take all of the data, which is typically how a lot of these tools work, some of it may be too sensitive to use. Moreover, the source may not have permitted that scraping in the first place. And so you may be leveraging your use of the tool unauthorized data. But in terms of whether or not it's generally permissible to scrape, the law doesn't necessarily clarify this as being per se illegal. And so to a large extent, the copying is possible. And it certainly is possible for the copying to be of sources that are restricted in some sense, but generally because you've scraped doesn't mean you have unlawful data. What you need to be concerned about is scraping of data from sources that have already told you it shouldn't be scraped. And so when you're looking at your own website, you may be asking whether or not your publication materials are something you want these tools to copy. It may make sense to start adding notices to say that the use of your publications is for limited purposes only. If you can introduce these ideas of restriction into the scraping concept, it is certainly possible for there to be copyright infringement, meaning that the copyright author or owner has forbidden use of information for scraping or AI purposes, and it is then taken by a tool. There is, in the online world, also a notion of trespass under what we call the Computer Fraud and Abuse Act. And then the websites themselves may be granting access and use under particular legal terms. Your terms of use or terms of service may be important considerations here, or whether or not your website permits both public access and then more restricted access to perhaps members, or registries one type or another. So there are a lot of ways to run afoul of various limits, notwithstanding the fact that the scraping of itself may be fine. And then finally, the nature of what is being taken may itself not be shareable. And so this is where the privacy laws enter the fray. In particular, in Europe, you generally can't take personal information and use it for any other purpose. And so you need to be concerned, generally speaking, about where the data came from. Next slide, please. As we've been highlighting, because this is important in a year where a number of states have put out new state laws governing personal information, in particular the collection and then its subsequent sharing for various purposes, you need to be highly sensitive to the kinds of data that may be used in the AI tool itself, both what you're submitting and also what you're making available. You need to be highly concerned about allowing particular types of data to be used at all. Data that you might others regard as confidential or a trade secret should generally not be used with open-ended AI tools. You want to be working with an AI provider that allows at least some siloing and limitation of data being provided to ensure that that trade secret status is maintained, because otherwise all the data gets compiled into a larger database, which by and large means it's been disclosed and possibly to all the other users. So you can easily compromise your trade secret status by enabling an AI tool to use the information. For those of you who are attorneys, when you're revealing information that otherwise may be subject to attorney-client privilege, that likewise may be blown by using an AI tool, because you're similarly making it available both to the database and the larger audience. And then finally, to the extent that the data you're submitting has restrictions, you can certainly breach contract. And as we've been noting, the personal information being shared may violate applicable privacy laws. It depends somewhat on your state, and particularly those of you who operate in California, but personal information is not freely shareable anymore. Next slide, please.
So while the submission of content to an AI platform can be risky from a privacy and confidentiality perspective, as AJ just discussed, it can also be risky from an intellectual property or IP protection perspective. So we've just gone through the trade secret risks, but AI risks can also include exposure of private IP information, as well as the potential infringement of an individual's right of publicity. An organization should be wary of using an AI platform to generate output if it will be submitting its organization's logos, unpublished intellectual property, or other content to the AI platform. As stated before, input that is submitted to an AI platform may inform output that is delivered to another user. So submission of an organization's own IP, while logical to accomplish a purpose, may risk muddying the exclusivity of that organization's IP asset. So for example, if an organization submits a logo to an AI platform seeking for the platform to create a particular type of content using that image, while the AI platform may do this as instructed, the AI platform has now also received that logo, where it may then use that information as a form of training data to inform the AI platform's generation of output for a different user. Thus, a user, let's say user B, unrelated to the organization, let's call the first organization user A, may receive content based on user A's logo. It's unclear, of course, if such a resemblance would be material enough to weaken user A's IP asset, but the risk exists. And similar issues could arise with submitting an organization's educational materials, graphics, or other content to the platform. So when an organization is using an AI platform and does not have much negotiating power over the terms and conditions of the license, submitting any content is risky if the organization submitting the content is entrusting the AI platform to keep that information completely confidential. Relatedly, A user should also be wary of using a work that is created by a different party to instruct the AI platform to generate similar content. While historically courts have not found that content developed in the style of an existing artist or work to be copyright infringement, users of AI platforms should still be careful when using existing content, such as, again, a logo or an image, to inform an AI platform to develop similar content. Using the logo example again, for example, using an existing logo to generate content using that same logo, but making a small change, such as the organization's name or colors. As a general practice, use of existing content to inform new content always presents copyright risks, which could lead to legal fees for simply having to address the infringement allegations. So the AI platform user should evaluate the rights associated with any existing content it uses to instruct an AI platform before publishing the output it receives as its own. Use of an AI platform can also lead to potential right of publicity violations. The right of publicity generally is the right of an individual to control the economic use and exploitation of its identity. In most states, this right extends to an individual's name, image, and likeness. The majority of US states recognize this right via statute or under common law. Those states do vary as to whether the right exists after death or in other contexts. Generally, infringement of this right means the use of the individual's name, image, or likeness without that individual's authorization and in a commercial context, but subject to certain exceptions. In the context of artificial intelligence, use of a celebrity or an individual to sell a product may violate that person's right of publicity if the person's permission has not been obtained. This past year, in particular, has seen the use of celebrity voices and images to create content or display events that in actuality did not occur. For example, use of a celebrity's voice to publish a song the celebrity did not actually record, or use of a photograph of a celebrity to create an image of that celebrity wearing clothes that they did not actually wear. So if using a person's voice, appearance, etc., even in a flattering way, it is best to seek permission from that person to ensure that the person maintains control over how the person's image is used economically, thus avoiding a right of publicity action. And for a nonprofit organization in particular, it should be aware of this right when seeking to use an individual's image to promote a campaign or to otherwise suggest that individual's association with or endorsement of the organization and its activities.
Moving on then, I first want to pause and share that the CLE code for today is artificial 2023. Again, the CLE code is artificial 2023. So with the increasing popularity of AI tools, this certainly is generating a lot of new questions, many of them legal, and this is resulting in a lot of development of guidance, policies, proposals, and possibly new laws. Next slide. But as of today, there is not currently a consistent nationwide approach to regulating or managing AI in any respect, or even, frankly, automated decision-making, which is part and parcel of how a lot of output is generated. And so we can't really tell you that there is a singular law we can look to. In fact, it's probably right now a complex assortment of policy statements and existing laws that will govern AI usage itself. But certainly wish to highlight a number of entities, prominent entities that are weighing in some of the key concerns and questions. The Biden administration, the Copyright Office, the Federal Trade Commission, and a lot of state government agencies have been publishing written guidance on how to practically and safely use AI. So they're not prohibiting it, but they are providing guidance on how AI tools should be used. And the White House has just recently issued an executive order addressing a number of hot topics in the AI world: safety, possible discrimination, possible fraud related to the right publicity issue we just talked about, and other issues stemming from AI use. And it's pushing all the federal agencies and Congress to act in response. So although we can't really say just yet this executive order has led to any specific rules or mandates, it's certainly driving the process forward. The National Institute of Standards and Technology, NIST, which has been a prominent organization developing information security framework, has released AI risk management framework itself on how to mitigate risk associated with use of AI. Although this is geared for the government contractor, it is highly relevant in the commercial and certainly the nonprofit space as well. There are a lot of IP questions out there, chief among them related to copyright laws. The copyright is in the midst of trying to develop additional guidance and has released guidance on, chief among them, how to register or what registration considerations you might have for AI-generated work. And we're going to talk about that a little bit. The FTC has issued warnings about possible privacy, antitrust, misinformation risks. Again, not all output is accurate from an AI tool. And finally, there are a lot of state-driven privacy laws that may weigh on AI usage and the use of particular data. Next slide, please. There are too many laws right now to mention, both those proposed and existing, but with this slide, we wanted to highlight that this is an evolving area and that it'll be important to stay abreast of changes, both at a state level and then at a federal level. And certainly, if your organization operates on a global basis, other national laws will apply. We've put up a few here. Some are proposed, some are existing. You'll notice the GDPR, the current California Privacy Act, both will apply to AI usage, notwithstanding the fact that they weren't drafted. So even though there aren't any specific AI laws that we can really point to at this stage, there are a lot of laws out there that may still apply and that you can leverage. And so it's important for your organization to remain aware of this point, that this is not a tool that you can freely use without any consideration of existing laws. Many of the existing laws that are there were still applied to AI usage. Next slide, please.
Okay, and moving to part 2, the content that is generated by an AI platform or the output can also prevent legal problems just as the input can, particularly if that content is then used and distributed by the user. So next, during this section, we will go through some of the risks of relying on output for factual assertions, some copyright ownership ambiguities, and existing IP loopholes. A hallucination, as we've put on the screen, in the AI context refers to when an AI platform generates false information. While artificial intelligence is increasingly being used to efficiently create content and gather information on a variety of topics, it is not field-proof. So it is risky for an organization to rely without fact-checking on the information it receives from an AI platform. For example, if a user asks a chat-based platform a question about a topic, receives an answer, and then uses that answer to inform content that it distributes to the public, the user or the organization may risk reputational harm by conveying incorrect information. The user should not assume that all information returned as output is accurate. The user should also consider that output may also be based on outdated information. The law, technology, academia, et cetera, is ever-changing, and the AI platform may not keep up with every event as it occurs. Certain AI platforms, in particular, actually note in their terms that their knowledge bases are limited to data from a certain year, which would prevent the platform from being able to answer current questions or return output that may be impacted by more recent events. In addition to fact-checking material it receives from an AI platform before using that information for educational materials or other content, a nonprofit in particular should also be wary of accepting material it receives from its members, third-party workers, or employees as fact. Given the increased relevance and accessibility of AI platforms, an organization could be using hallucinated information without knowing it, because its own workers or other associated parties have used AI platforms to generate content that they then submit to the organization. For example, using AI to inform presentations or to inform research contributions. Going to copyright ownership. Generally, if an author creates a work, such as a written work or an illustration, the author's work is automatically protected by copyright, and the author can also register that work with the Copyright Office to ensure additional protections, such as the ability to enforce exclusive rights to use the work in court. However, the influx of AI-generated works poses the question, can a work developed by an AI platform be protected by copyright? And can it be registered for copyright protection with the Copyright Office? And who is technically the owner of the AI-generated output? The Copyright Office has published guidance on some of these questions, in particular determining the copyrightability of a work that incorporates AI-generated content. Recently, for example, the Copyright Office decided that a graphic novel that included human-created text and AI-generated images was copyrightable, but the AI-generated images themselves were not protectable by copyright. To give some context to that decision, the office published a notice that it would cancel an existing copyright certificate issued to the author of the graphic novel because the certificate did not acknowledge that the AI-generated content was not included in the protection, and the office would then issue a new certificate that covered only the human-created material. In its guidance, the Copyright Office also notes that it has historically required that copyrighted works be the, quote, product of human authorship. For AI-generated materials, the office notes that it will consider the degree, then, of the AI's involvement in creation of the work. For example, it will consider if the AI merely assisted in the development of a work, or if the work was written, illustrated, etc., completely by the AI machine. Further, if the human author modifies material that was generated by AI to a degree that the modifications meet the standard for copyright protection, copyright may protect the human-created aspects of that work. The office in its guidance uses the example of an AI-generated poem. If a user instructs a machine to write a poem about a certain topic and in the style of a certain writer, for example, the machine will follow the instructions, but will also, in doing so, have to decide on the rhyming structure, the particular words, organization of the text, and make other creative decisions for the poem. The poem then would not sufficiently be the result of human authorship and thus would not be protected by copyright. If an organization then uses an AI platform to create a work, the Copyright Office's guidance suggests that only the human-generated aspects of the work are copyrightable, but not the computer-generated aspects. This is notable for an organization in that while an organization may own an AI-generated work from a contractual standpoint, it may be more difficult for the user or the organization to argue that the AI-generated content can only exclusively be exploited by the organization under copyright law, or to assert that another party has infringed on the AI-generated content.
We want to emphasize in talking about the current state of copyright as it relates to AI is that the copyrightability standards for AI generated works are varying by country. Not everyone is going to follow US guidance or US approaches. We wish to emphasize this and show that in the United Kingdom, at least, works created solely by a computer are in fact protectable. But consistent with the United States, the author of the work is not the AI tool itself. It's the person who used the tool. This is different right now than where the US is, but we may see some reconciliation over time simply because a number of countries operate on treaties that recognize registered copyrights. And so if we start to have some substantial differences between the various countries, then there will probably be some emphasis on aligning things. But for today, I think the short answer is that an AI tool or computer cannot be the author. And that if a work is solely created by an AI tool without any human intervention whatsoever, It is not protectable by copyright law. Next slide, please. But that still leaves a whole bunch of questions. And I got to note that we are getting some questions in, which we'll try and address at the end, but maybe some of what we're going to identify here as current or lingering IP loopholes may show you that there are still a number of things to be resolved. In particular, who might have a cause of action for stolen AI-generated works? Is the cause of action against the user? Is it against the platform? Unresolved. Can a user automatically own the output as work made for hire? So this is definitely important consideration for nonprofits who are using AI tools to create content. Also, we wish to note that the Copyright Office has issued guidance that an AI tool or machine is not an employee for purposes of the work made for hire doctrine. So again, emphasis on human involvement, human intervention. If you do not have that shown, then you arguably do not have content that is copyright protected. What constitutes a derivative work? In particular, are outputs generated from AI tools derivations of underlying copyrightable work? They may be, but we don't have definitive guidance on this. We also don't have guidance clarifying how much of a change, etc. I think for now, it's best to look at how derivative works are generally handled and apply that against the content at issue. Again, recognizing that AI-generated content without human intervention is not protectable at all, but some blend of the two may be. And so it may give rise to derivative works that are separately recognized. And finally, will AI machines ever be considered people, meaning they have author inventor status? I think in the near term, no, but who knows over time as the tools become more complex and better developed. Next slide, please. So we're going to go over a bunch of best practices as we see them. These are generalizations for now, because we want to emphasize, notwithstanding today's presentation, that the intent here is not to prohibit or forbid use of AI tools, just to use them in a better way and not to view them as infallible or perfect solutions for all tasks. And these best practices primarily relate to use, but also licensing. Next slide, please.
Okay, so first on this slide, we've listed some general best practices for organizations using artificial intelligence. So going through them, number one, a best practice is to establish policies for AI use by members, contractors, employees, and other workers. In particular, this means that it is wise to require workers to acknowledge in writing that maintaining confidentiality of information includes ensuring that any confidential information is not submitted to an AI platform, unless the organization has granted the worker permission to do so. Number two, stay abreast of data protection laws and AI-specific legislation developments. Number three, avoid, in line with number one, avoid submitting confidential information or trade secrets to an AI platform and encourage employees to avoid doing the same. Number four, review the terms of use or frequently asked questions of the particular AI platform used by the organization to understand the AI platform's views on ownership and any use restrictions for output. For example, some AI platforms actually prohibit commercial use of the output generated for its users. So ignoring this or other restrictions could be a contractual breach of the AI platform's terms of use and then open the door to legal complications for the organization. Number five, in line with our early discussion on potential infringement of a third party's rights, when using pre-existing content to instruct an AI platform or using the output based on that instruction, an organization should review the rights associated with any input it submits to the AI platform and rights that might be associated with any output received before publishing that output. Number six, organizations should fact check any content generated by an AI platform or publishing content based on that information. And lastly, for the purposes of this list, when using AI to generate content, particularly when that content is going to then be delivered to another party outside of the organization should disclose to that other party that AI has been or may have been used in the creation of that content.
We want to emphasize that when you're using an AI tool or any AI solution, your organization is most likely subject to an existing license agreement governing that use. You may not be aware that a license exists, may not have seen the license terms, but appreciate that all use is generally going to be subject to a license agreement. And that your ability to change that license agreement is going to vary. So we're going to read it verbatim here. The organization may have negotiating power in dictating the terms of the arrangement, but they may not. In instances where you're using some of the mainstream tools out there, say from OpenAI or Google or others, you are likely not going to have any negotiating power in changing the terms. But that doesn't mean you shouldn't read the terms to understand the considerations involved, the limitations, some other things we're going to highlight in a bit. And then in other instances, and we've already seen this occur, you may be presented with requests to enable scraping or copying of your website, of your publication materials. We know there can be a bit of a tension there in getting your content out, and that things are often publicly available on your site. But we would encourage any of those requests to be met with license terms that govern further use and distribution. Think of this as a publishing arrangement. You wouldn't necessarily allow an author to take all your publications and repurpose them elsewhere without permission. Same thing holds true with requests to use your data. Not all of the AI tools are being provided by very large entities. You will have niche-specific entities, specific to the nonprofit world, that will ask. And in those cases, you should definitely be dictating and perhaps have your own AI license, so to speak, for permissible use of your tools. Next slide, please.
Okay, organizations may also be presented with opportunities to license their content to an AI platform provider, enabling that provider to use the organization's content as training data, such as an organization licensing out its educational content or materials to an AI platform provider in order to train or inform the AI platform about that educational material. As an example of this today, OpenAI and Associated Press recently entered into a license agreement permitting OpenAI to train its AI platforms using Associated Press's content. While it's difficult to pinpoint a particular template or standard for this type of license agreement as of now, this type of agreement may resemble more traditional data license agreements where the organization would be able to determine the scope of the information that's licensed, the period of time and purposes for which it may be used, security standards, and fees, among other details. So on one hand, licensing of an organization's materials as training data could be a lucrative way for organizations to leverage the AI boom and maximize the organization's content. On the other hand, however, the organization should still be thoughtful about if this type of license is in its best interest. For example, if the organization values its content being more exclusive, this type of agreement may not be beneficial. If an organization does choose to enter into this type of agreement, it should speak with legal counsel to draft and negotiate the terms of the agreement with the other party.
Before using any AI tool or even agreeing to a license, whether by use or more affirmatively, you should probably ask yourself why and go through a host of questions related to the AI tool's use itself before you get there. In terms of questions about whether or not you should have an AI policy for use, we actually believe you should. I wouldn't say at this point there's any standard format for this, but certainly we have a number of ideas on things to consider, some of which are very practical, which we're outlining here. First of all, what is your organization trying to achieve with use of the AI tool. And this is another way of saying what your organization will allow your employees or personnel to use an AI tool with or for. And then what will the AI enable, accelerate, automate? Are there pros and cons to using the AI tool versus not? And then last but not least, and this is probably most important given the number of things we've been highlighting today, what data will be integrated or ingested? And will that ingestion or integration create a risk or violation in particular of privacy laws or any use of personal information or of use of confidential or contractual obligations? Not all AI tools work the same. Some will enable you to better manage the use of your more sensitive data than others. And so it's important to ask these questions in advance and to perhaps clear use of AI tools and the corresponding license, just as you would any other tool that your organization has used in the past. And so you have gone through this in certain respects for email, for social media. You need to be taking that same lens and applying it to AI as well. Next slide, please. If you are evaluating a license, and we've seen all different shades of this, you, again, may not have the ability to negotiate per se, but to the extent that you do, or that you at least want to consider some of the important elements of the license, we're going to highlight some of the terms you definitely want to go over. First of which is what terms and how will the licensor ensure privacy and confidentiality of your data. You absolutely should be evaluating this regardless of the nature of the data that you're providing. Next is if you are providing data to help train the AI tool, how is it collected, stored, who will be shared it, what rights will each party have to this data under the terms. There can be a lot of variability here, so you need to understand in advance. You may not have terms that are appropriate for the nature of the data you're providing, and that's something to think about. What will happen when the agreement is terminated? You get your data back. What will happen if the licensor breaches the agreement? Do they offer indemnification for third-party claims for generating content that violates copyright law, right of publicity, etc.? What if the AI platform goes down? If you're using a tool that you're going to rely upon, does it provide any assurances or promises that it will be available when you need to use it? What security measures are available for the data that the AI tool stores or works with? This is no different than a lot of other SaaS or cloud considerations that you might have. You need to start looking at your AI tools the same way. And then last but not least, who's ultimately going to be allocated the responsibility for liability, in particular third-party claims? You're seeing there's a lot that's unresolved at this time, and so it's important to go into these licenses understanding which parties are going to have responsibility. At this point, you may be facing licenses that are rather one-sided. Certainly for the tools that have nominal fees that are generally available, you are not going to have a lot of opportunity to negotiate them. And you just need to understand the limitations of those terms. Perhaps evaluate different providers. There is not just one AI provider out there. That field is growing. That's something that's part of the Biden's administration executive order. So one tool may have better terms than another. It's important to evaluate in advance. And also, when you, as an organization or a content provider, are being approached to have your content, your publications, your data incorporated or ingested, you have more opportunity to dictate the terms there. Maybe that's a more negotiable document, or maybe you have your outright form that says, this is how we work with AI tools. These are our terms. No different from any other publication or distribution arrangement you've had in the past. Next slide, please. So we have a little bit of time left to go over the questions that we received. We'll do our best to answer them before we end our presentation. I'm going to read them off as they've come in. First one is, do you recommend a policy or statement for online meetings related to the note taker function? Prohibiting or explicitly allowing? Is it legal to record through note taker participants without their express permission? Short answer here, and this isn't really any different since we're using Zoom, if you're going to be recording, we generally recommend that you provide some notice. They may not necessarily require explicit consent, opt-in permission, but you certainly should generate permission in the form of an opt-out by saying, do you agree to have this participate in a presentation where this will be recorded? But that will be better than nothing. So the short answer is yes, you should seek the permission, but doesn't actually have to require opt-in consent at this time. At least try opt-out by providing an acknowledgement of some kind. Next question. What are some legal considerations when building an AI platform leverages financial data, including public and non-public financial reports? At this point, look at that no different from any other cloud solution or software tool that you've used in the past. All the same considerations apply. Just because it's AI doesn't change anything. The same financial rules will apply, the same information security concerns will apply, etc. I think with AI, though, you need to appreciate that certain platforms, when they take in the data, may be permitting the data to be used for a lot of purposes for which you may not fully comprehend or permit, and that further, that data may be more freely available for use to others. It's not so much that the AI data takes your information, turns around and shares it. It's just that it can be pulled from the AI tools sometimes in a way that will allow the data to be, in a sense, copied and redisplayed somewhere else. By way of example, tools that ingest social media posts are highly able to determine an individual's name just by taking all the data and compiling it together. So if they can do it with social media, they can do it with more sensitive financial information. Next question. If our material is already copyrighted, do we still need some sort of scraping restriction? I don't think you necessarily need a scraping restriction per se, but you definitely want to have a proprietary rights notice. And you may want to beef up your terms specifying what is or is not permissible use. So if you haven't been doing that in the past with a copyright notice or with terms that speak to permissible use of your content, now's a great time to get on top of it. But it doesn't necessarily have to be scraping permissible. It just needs to be accounting for what is permissible use versus what isn't. Question 4, how do we prevent our data from being scraped? Outright prevention, take it behind a gate. Don't leave it on the site that's freely able to be scraped. So if you have it up on a publicly accessible aspect of your site, put it behind a password. Because once there, you can include terms that say that this is available for limited use or in particular personal use. But outside of that, again, have a proprietary rights notice, incorporate terms that restrict or at least spell out what is or is not permissible use. Next question. What are your thoughts on employees using AI-enabled note-taking services and a meeting Zoom feature in Zoom? I would ask that you give consideration to more organizational approaches on what they should or shouldn't be using, particularly those that involve recording. As we mentioned earlier, with recording, it's at least advisable to have some kind of opt-out notice to say, hey, we're recording this. If you don't want to participate, leave. Or to say that if you do participate, that this meeting will be recorded. And so I would advocate for a more organizational approach to this rather than leaving it to individual employees or personnel to make their own determinations on what or how to use. So the short answer is they shouldn't be using these automated services without at least some awareness by the organization and the involvement of IT. If it's something the personnel are going to use, settle upon permissible term or solutions that you like and usage. Next question, how is scraping not a reproduction and or preparation of the derivative work for purposes of the Copyright Act? It sort of depends on what you're using the scraping to do. But to a large extent, the mere copying of things online isn't per se infringement. Otherwise, no hypertext linking would ever work. So there is case law related to linking which is largely how the internet functions. And so some aspects of scraping are fine, but it sort of boils down to what you're going to then use the scraped content for later that may give rise to copyright infringement, and how much of it. We can certainly tell you that if somebody copies a copyrightable work, say an entire publication, with an AI tool and repurposes in a hole somewhere, that undoubtedly will be copyright infringement. Same thing holds with other types of better known content like a song or a piece of art. Next question. Everything I write is based on other writings I've seen, all presumably subject to someone's copyright, but is original with me. How is that different concept from AI producing something original based on right? This is all back to basic copyright law of whether or not your work is original creative work of authorship or whether it is based and essentially copied from someone else. And so with copyright law, always appreciate that it's based on outright copying. So if you copy verbatim someone else's work, you are engaged in copyright infringement. On the other hand, if you are simply writing your own original work, you may be copying an idea, but that isn't covered by copyright law, and patents don't really apply to this type of content. And so we haven't really moved this at all. Really, the questions boil down to whether or not the AI creating the content is creating something that's protectable, because the AI tool is generating content that may meet the threshold for originality or creativity, but it's by an AI tool. And how much of that creation is created by a human? And so those are things we still don't have resolved. But the basic concepts of copyright haven't changed, and they won't change. All right, this will be the last question we have time for. Certainly you see our names on the screen. There are a few others, but last one is, what if AI is used to rewrite existing company documents originally written by persons and copyrighted? If it's done strictly by AI, they are not going to be copyright protectable. I think the thing to take away from this presentation is a computer cannot be an author or an inventor at this time. And so you're going to want to have some human intervention and involvement that you can demonstrate. So if this is what you're doing, where it's just all automated by AI, we would come up with another way to think about this. Maybe demonstrate that you are directing the tool to create the new documents so that there is at least some evidence of AI involvement, so the AI itself becomes more of a tool that's used like pen and paper rather than the AI creating it all by itself, because that's not what's copyrighted. And thanks, everyone. There was a lot covered here today, but we hope you came away at least with some appreciation for AI considerations, and have a great day.
Thank you.